Hello everyone, myself Vashundara Sahu from MSc Third Sem Biotechnology. I am doing my MSc from St. Thomas College, Ruabanda, Bhilai. Today we have to discuss about intellectual property rights. These are the synopsis. Introduction, history of IPR in India, protection of IPR in India, trade secret, patent, copyright, plant breeders' right, geographical indication, benefits and problems of IPR, and then references. So, firstly, we can discuss about the properties. Property is any item that a person or a business has a legal title over. Now, as we know that there are two types of properties. First, physical properties and second, intellectual properties. Physical properties is any property that is measurable, whose value describe a state of a physical system, for example, vehicle or any electronic device or plots, etc. Intellectual properties. An intellectual property is an idea, design, or invention or manuscript which can ultimately give rise to a useful product or application. Or we can say that somebody has an invention, idea, or a design has created by their own. The rights of the inventor to derive economic benefits from his invention. These rights is called intellectual property rights, as we called as IPR. The IPR is a right of inventor who can propose the innovative inventions. These are the history of IPR in India. In 1856, the Act of Protection of Invention was proposed. In 1888, Invention and Design Act was proposed. In 1970, Indian Patent Act was proposed. In 1911, Indian Patent and Design Act was proposed. In 1957, Indian Copyright Act was proposed. Protection of IPR. The protection of IPR may take several forms depending mainly on the type of intellectual properties and the type of protection sought. Each form of protection has its own advantage and disadvantages. The main form of IPR protection are as follows: trade secret, patent, plant breeders' right, and copyright. These are the four main IPR protections which India has followed. First is trade secret. A piece of information or a particular product is made that is known only to the company that makes it. When the individual and the organization owning an intellectual properties does not disclose the property of anyone and keep it as a closely guarded secret to promote his business interest is called trade secret. And in biotechnology field, the examples of trade secret is cell lines, microorganisms, strains, production process, etc. And in general, the examples are formula of Coca-Cola, etc. Advantages and disadvantages of trade secrets. First we have to discuss advantages. First, they are unlimited duration. The cost of filing, contesting, and enforcing patent is saved. The risk of someone improving upon the product, process, etc. is minimized. And the drawbacks are: maintain a trade secret itself is a costly affair. It cannot be applied to any invention, equipment, plant varieties, books, etc. A patent is a type of intellectual property that gives its owner the legal right to exclude other forms making, using, or selling an invention for a limited period of time. Patent in 1970, pharmaceuticals and agrochemical don't have patent right, but after the amendment, these should also allow in 1999. Basmati, for example, Basmati rice patent by Rice Tech Texas in USA in 1997, but the India claimed that the Basmati rice was the production of India in 1999. The patent was granted for an invention, innovations, improvement in an innovation, the process and products of an invention, or concepts. Requirements and limitations. So, patent has some requirements. First, novelty. Second, inventiveness. Third, industrial application and useful. Fourth, patentability. And fifth, disclosure. Limitations. There are two basic limitations. First, limitation of time, and second, limitation of space. First, limitation of time. It can be granted for 15 to 20 years in India. Limit and the limitation of space. The limitation of space that the patent has allow in the same country where it is awarded, not in the other countries. So this is the limitation of space, and these two are the limitations of patent. Copyright. It is a legal term used to describe the right that creators have over their advantages and disadvantages of copyright. First, advantages. Prevention of monetary loss or money loss, legal protection, the incentive to create to appreciate um, the work, protecting reputation, and disadvantage. The primary disadvantage for copyright is that copyright protected the expression of an idea, not the idea itself. It can protect the expression of idea. Plant breeders' rights (PBR). PBR, also known as the plant variety rights, are rights granted to the breeders of a new variety of plant that give the breeder exclusive control over the propagating material. PBR, the right granted by the government to the plant breeder, originators, or owner of a variety to exclude other form of producing or commercializing the propagating material. Its time period is 15 to 20 years. PBR system also contain some forms of breeders exemptions and farmer privileges. Plant variety and animal breeder was protected by the PBR. Benefits and disadvantages from PBR. Benefits: the opportunity to breeder of obtaining profit from variety developed by them will act as an incentive in propagating plant breeding research. It encourages private companies to invest in plant breeding activities. Disadvantage: the holder of PBR title may produce less seed than the demand in order to increase prices for achieving more profit. PBR may result in increased cost of seed, which will be burden to the poor farmers of India and would limit the benefits from new varieties to a small segment of rich farmers. This is the main disadvantage of PBR. Geographical indication. Geographical indication is a sign used or products that have a specific geographical origin and possess quality or a reputation that are due to that origin. Geographical covers such quality, reputation, or other characteristic of a product that could be used to recognize that a product has originated from a particular territory, region, or locality. Agriculture goods, natural goods, manufactured goods, goods for or handicraft, food products are examples of geographical indication. For example, Kanchipuram silk. These represent the Kanchipuram silk. Darjeeling tea was the first indication product. Geographical indication product. In international level, the geographical product has other examples such as Scotch, whiskey, champagne, and California wines. India has enacted that Geographical Indication Act 1999 to claim geographical indication for a variety of goods. Benefits of IPR: it enables the dissemination of new ideas and technology quickly and widely. This is achieved by the requirement of disclosure for grant of patent, etc. It allows owner of intellectual property to have financial benefits from the property they have created. It improves the financial status of the individual as well as the economic of the country, to create competition among the researchers and institutions for quality of research. Such rights motivate individual creativity and thus also contribute to economic growth. It encourages investment in research and development efforts. Problems from IPR. The IPR situation in many cases is quite complicated. Monitoring and tracking the IPR assets of inventions enhance cost, demand time durations and efforts may act as disincentive for research and development efforts. It may adversely affect biological diversity and ecological balance. It may be detrimental to the livelihood of the poor in developing countries, as we earlier told that the poor farmers cannot afford the seeds which is demand in agriculture. It is perceived by many as threat to food security. So these are the references of the books. Thank you so much for hearing my PPT presentation.